Okay, welcome to this session of the Kansas Court of Appeals. We have one case today we're hearing that was continued from Monday. And we are, of course, conducting oral argument by Zoom on this case. It is being recorded live and it will be posted on our website. The only difference between this particular session and others is we will not be having closed captioning at this session because of its late setting. We weren't able to get closed captioning lined up. So that would be the only difference. I'm Karen Arnoldberger. I'm the Chief Judge of the Court of Appeals and will be presiding over this event, which simply means I keep time. Judge Bruns is also on the panel with me today. He's a former judge in Shawnee District Court and joined the bench just a couple months after I did. One of our newest judges is Judge J.C. Hurst, who joined our court last year and is one of our newest members, and we're happy to have her with us here today. We are very familiar with the facts of your case, so you don't need to spend a lot of time on the facts. You'll each have 15 minutes. And Ms. Quinn, I'd like to know if you would like any time for rebuttal.
5 minutes.
5 minutes for rebuttal? Okay, yes. Thank you. All right, so with that, I'll call the case 124674, Robert Quinn, appellant versus State of Kansas. So if the parties would officially state their appearances, please.
May it please the court, the appellant, Robert Quinn, appears by and through his attorney, Rosie Quinn.
Okay, thank you.
May it please the court, Deputy District Attorney Kayla Rayler appears on behalf of the State of Kansas, the appellee.
Okay, thank you very much. All right, Ms. Quinn, we're ready when you are. You're all systems go.
Now, although the district court summarily denied Quinn's 60-1507 motion for timeliness, the judge should have extended the 1-year requirement based upon manifest injustice. Quinn was convicted of a crime. He was incarcerated. The direct appeal was denied. He had no understanding of the law to fight his conviction, but suddenly he receives a letter from the judge telling him he has been appointed a lawyer to represent him in a further appeal. Quinn never hears from the lawyer and writes letters to the judges telling them he needs legal assistance. After about 1.5 years, Quinn receives notice from a different judge appointing the same lawyer to represent him in a 60-1507. The lawyer never contacted Quinn to discuss the case. Instead, eventually the lawyer had conversations with the court. The lawyer was allowed to withdraw without notice to Quinn, and Quinn was never appointed a lawyer again. This is extremely unfair. It involves judicial conflict. It involves allowing a lawyer to withdraw contrary to the rules. And so though Quinn continues to write letters asking for a lawyer, who's eventually told, and I think led to believe, that all you have to do is get something on file and we'll see about appointing you a lawyer. Mm-hmm. Manifest injustice. How could this be fair? The court, for lack of a better word, lulled the appellant into thinking that he had a lawyer, and they snatched it from him. Snatched it from him. Even if they didn't have to appoint a lawyer to him initially, when they chose to appoint him a lawyer, they should have made sure the rules were followed.
So are you saying, is your argument that he somehow detrimentally relied on the fact that he had a lawyer and didn't assert certain rights because he thought his lawyer was going to do so? Or
absolutely. He thought, based upon the pattern that had been exhibited with the court before, him writing them letters, it taken a long period of time, he thought that they were going to appoint him a lawyer. And
I'm sorry, Ms. Quinn. And did he receive the letter from the court within the 1507 timeframe?
We're talking about two issues here.
Okay.
He received the letter from the court appointing the lawyer for appellate court purposes shortly before the original mandate had been filed into the district court. And this is all related insofar as if the lawyer who he had been appointed for appeal purposes had looked at the mandate, had seen that there was something wrong with the mandate, they would have been able to pursue those appellate purposes. And the 60-1507 could have been filed sooner after the mandate was straightened out. And the mandate, let's not be deceived, that mandate is extremely important. It's not only the decision of the denial of review or the opinion of the court that forms the judgment in this case, it's also the mandate. And if a mandate is issued that is defective, it cannot be the basis for a valid judgment. Now, I'm not saying that the decision of the district court would have been changed, but until a mandate is issued according to the law, how could jurisdiction be transferred back to the district court
Okay,
so
and Ms.
that the
Quinn,
process could have been right?
what would you say, what is your strongest argument that mandate is tethered to the time requirements for filing a 60-1507 motion,
The strong,
rather than simply the date the Supreme Court denied review?
without the mandate being issued properly, my argument is that the time for filing the 60-1507 never began.
Right, because you're saying it somehow that the time frame starts with the issuance of the mandate. But would you agree that 1507 says that any action must be brought within 1 year of the final order of the last appellate court to exercise jurisdiction on a direct appeal?
Correct. I agree
Okay.
that it says that. But
Pardon?
don't we presuppose that the mandate is proper? But let's take it another step, Your Honor. This court did, in fact, resume jurisdiction of this case.
Mhm.
And therefore, the 60-1507 should not have started to run the 1 year until after the Court of Appeals jurisdiction ceased on the direct appeal. The mandate, the jurisdiction of the appellate court was exercised solely within the direct appeal. And the statute does not tell us any particular time that that a person needs to file a motion when they dispute the mandate. Matter of fact, the case law said it can be done at any time.
Okay, and would you agree that the statute provides that, or the statute or the rule, I'm not sure which one at this point, but the mandate isn't even required to be sent to the defendant.
Correct.
The mandate is sent only to the district court to advise them that of the resolution of the case. So how would a person know when their 1 year had started if they aren't even entitled to a copy of the mandate, if your argument holds water that we start that year from the date of issuance of the mandate? Do you
Well,
follow my question? It was kind of convoluted.
you know, I do. And my only response to that is this. The judge was given a copy of the mandate,
Mhm.
and as a result of seeing that mandate, he decided Quinn needed a lawyer for appellate purposes. And that's the purpose of lawyers.
Right.
We get to see those things. We get to determine if there was something improper in the procedure.
Ms. Quinn, are you familiar with the case of Tolan v. State, which is a 2008 Supreme Court case? And if so, how would you distinguish that case?
Your Honor, I feign ignorance.
Okay, well, that's fair. I didn't know about it until recently myself.
I don't know anything about the case. And Judge, if I may go a step further, at this point in my life, it's hard for me to remember cases. But I definitely don't know anything about that case.
Well, let me give you just a
Okay.
real short summary on that. It just kind of confirms the statute, and it says the time runs from the date of the decision denying the petition for review and not the date that the mandate was issued. And it seems like they serve two different purposes: the petition for review and the order denying that, and then which certainly the clients and attorneys and everybody needs to know about. And the mandate is a little different because it's more ministerial, directing the court to take action on the appellate judgment. So with that knowledge, is there any comment you'd want to make?
Judge, though I'm not familiar with the case, I'm familiar with the theory.
Mhm.
Right.
Okay. All of that is premised on a belief that the mandate is just a ministerial act. It should be done correctly without errors. It should not be defective, because without that mandate that should have just been cut and dried, the jurisdiction becomes an issue. So that's the difference. If the mandate, in this case even, had been correct, you could have started this process from the date that the decision was entered. But that wasn't the case here.
So
And-
how did your client detrimentally rely on what you're calling the erroneous mandate? How he didn't even know it was there
Well, but
and wasn't entitled to know it was there.
Your Honor, isn't that like saying that because we don't know our constitutional rights or our rights in general, that it's okay for someone to deny them just because we didn't know about them? But because they are there, you have a right to rely upon them.
One other question, Ms.
Yes.
Quinn, how would you view this as any different? You know, we have nunc-pro-tunc orders that are entered all the time to correct journal entries that may have an error. And the law seems pretty clear that with a nunc-pro-tunc, the date relates back to the original filing. It doesn't create any new later date. How would a mandate be? Why should we view a mandate any different than we do a nunc-pro-tunc?
Judge, I question whether nunc-pro-tuncs are even permissible with the mandate issue.
Right.
And-
I'm just saying, how are they different? In a nunc-pro-tunc, we say, okay, there was an error in the journal entry. We're going to allow the court to correct it. A nunc-pro-tunc order is filed, but it relates back to the original filing of that journal entry.
Okay, but this is not a nunc-pro-tunc. It
Right.
did not relate back just because it was erroneous.
Okay.
It had to be recalled.
Mhm.
And the truth is being spoken at the date the new mandate
Correct mandate.
was issued.
Okay. Right. I follow you.
Okay. Oh, I'm sorry.
Yeah, you can keep going. I'm
Oh,
sorry.
no.
I got
Wait,
you
wait,
off your
wait.
train of
Okay,
thought.
now, and in addition to manifest injustice, Judge, there's no way in the world that Judge Roberts should not have found manifest injustice because he knew the situation of the appointments of Quinn. But even beyond that, Judge Roberts looks at Quinn's motion and he states that Quinn says that I did petition the Supreme Court and Quinn said it was denied, but I can't find a record anywhere of that.
Mhm.
The light bulb should have gone off somewhere that we have a serious issue here.
Mhm.
And because there is an issue that was raised in Quinn's motion and the court's reconciliation, it was definitely time to appoint a lawyer so that answers could be had of this, other than the judge says, I've looked and I can't find it. Because the judge knew or should have known that if there was a petition for review filed and it wasn't denied, that there wasn't a real serious issue there.
Okay.
Okay.
Your primary time is up now, Ms. Quinn. You'll still have 5 minutes in rebuttal, okay?
Thank you.
Ms. Roller? Is it Roller? Roller?
It's Railer, Your Honor. It's like
Oh,
short
I'm
Ridge
way off.
Fader,
Railer, thank you.
but I will answer to anything that the court
Okay.
wishes to call me. Your Honor, I'm going to start based on where the court ended its inquiry with Ms. Quinn, and that was the issue of the recall of the mandate and the reissuance of the mandate. Our Kansas Supreme Court has held that it is the date of the final decision of the last appellate jurisdiction that controls when the time frame starts for a KSA 60-1507. And in this case, that was August 20th of 2015. That was the date that the appellate jurisdiction terminated. Mr. Quinn did not file a writ to the United States Supreme Court, and our Kansas Supreme Court in Tolan, I think, is very instructive for this court, where it found that although the mandate was issued 2 days later, jurisdiction became final in the appellate court on the date that decision was entered when it denied the petition for review. And the Court of Appeals has routinely held that it is based on that final decision of the appellate court, despite when the mandate is issued. And I listed several cases that I rely on in my brief for the court for that position, because the state's position is the way the statute is written, it creates a close to a potential loophole that's being raised here, that if there's an error in the mandate, then these cases in KSA 60-1507s get to hang out there in perpetuity with no end in sight, because there is a typographical or an error in the mandate. So the statute, the way it is written, creates that closed end and adds finality to our criminal cases, which is the purpose of the one-year timeline, to provide a definitive kind of end date for those motions, for the criminal case, so that victims of these crimes can have some sort of closure. Going back to the issue that was raised today, the detrimental reliance on the attorney, Your Honor, that supposes that Mr. Quinn was even entitled to have an attorney where on the 1507 motion that hadn't been barred by res judicata or untimeliness. The issues he raised in his bare bones petition, volume 1, page 4, is where that starts. He only cites the conclusory statements that his counsel was ineffective and that the victim lied. Well, Your Honor, those issues of ineffective assistance of counsel were raised in 2015 and 2013 on the direct appeal. Mr. Charles Lamb was Mr. Quinn's direct trial counsel, and prior to Mr. Quinn's sentencing, Mr. Lamb withdrew. Mr. Quinn hired Mr. William who goes by Bill in our jurisdiction, Dunn, to represent him on the motion for a new trial, where he specifically alleges ineffective assistance of counsel for failing to investigate, failing to contact family members, failing to go into the facts of the particular rape. There was a conflict-free attorney at that motion for new trial where Mr. Quinn and Mr. Lamb testified before the district court, and there were rulings made. And those issues were raised on direct appeal in the Court of Appeals. And he is presumed under the KSA 1507 statute to have raised all of these issues on that first motion.
So your position is, it goes to your res judicata argument that we don't have to get to any of this because he had a duty to raise those issues in his direct appeal. He did raise them in his direct appeal and lost, and he can't come up with new reasons now for ineffectiveness of the same attorney that he could have brought up in the first appeal, in the direct appeal.
Correct, Your Honor. All of the conclusory allegations, and I apologize, I did not actually brief the
Right.
conclusory point, but I think the court can look at that with the district court being right for an additional reason, aside from the time bar and the res judicata, that what he raises in his motion is merely conclusory statements. He conclusively claims his attorney was ineffective, doesn't cite to new evidence. So there are three reasons why the court was proper in denying that. With regard to the timeliness issue, I just wanted to address kind of the timeline. Mr. Quinn filed a motion or a letter to the court. It is volume 2 at page 187, where he specifically asked the clerk of the district court for specific information in 2017 so that he could pursue a KSA 60-1507 motion and to get it on file. However, he didn't do anything after that. Not until 3.5 years later does he file it. So even if the mandate's wrong, there is no detrimental reliance, because with the filing of that letter, he knows he doesn't have an attorney. He says, I'm trying to get an attorney. I don't have an attorney. I need this information to file the 1507 motion. Please give it to me so I can get this on file. And then nothing. If the court,
I'm sorry. So that was a 2017 letter you're talking about.
Yes.
Right? So then when did he receive, what is the date that he received the letter from the court saying that he had a lawyer?
I do not see, when I reviewed the record, I did not see an actual letter to Mr. Quinn informing him that he had an attorney, other than the general orders that are filed with the appointment of counsel. I don't know if that went to Mr. Quinn. There's nothing in the record showing that it was mailed. There's no envelope. It just has like the order of appointment of counsel in the record. And I apologize, I don't have the page number in front of me.
No, that's fine. So earlier when Ms. Quinn was discussing the letter, it's your understanding that that is to what she's referring?
I'm not sure what letter Ms. Quinn is referring to, because I couldn't find, the only letter I could find in the record was a letter, I believe, from Chief Judge Burns after 2017, where he says, you don't have a lawyer because there's nothing on file for me to appoint a lawyer on. That was the only letter, I believe, based off of my memory, I could find.
So when you're discussing the detrimental reliance argument that was sort of brought up today, what do you think, what are you addressing with regard to that? Like, what are you saying he didn't rely on?
My argument,
we're talking about the same thing.
I'm trying to formulate the argument. My argument would be, and I think that goes to the timeline thing, because I think he sent letters to the court asking for an attorney. I do not see anything where the court responded, and I'm confined to the record, but I don't see a record of the court responding, here's your attorney. He says he's written to the court asking for an attorney. If he had received the orders of appointment, which I'm not sure criminal defendants receive in the criminal proceeding. I believe they get the contact information of their attorneys somehow, but I don't know because it's not in the record.
So you're saying he wasn't detrimentally relying based on his requests for an attorney?
I don't think he could if he keeps saying, I'm requesting a lawyer, I'm requesting a lawyer, I don't have a lawyer. And I think the 2017 letter actually shows that he didn't have a lawyer. He's saying, I've asked for an attorney, I don't have an attorney, which is also still well outside of the original decision date in this particular case. Ms. Quinn raises the appointment of an attorney. The original appointment for Mr. Wells was listed on the order as for a 1507. And in his motion, Mr. Wells explained, no, I was appointed for the second motion for a new trial, which was again raised on direct appeal. And he concedes to the court, I can't raise anything on this appeal because it was already heard by the Court of Appeals and denied. And I cannot raise any additional issues because there was no notice of appeal. That is the scope of my appointment, and I cannot raise frivolous arguments to the Court of Appeals. With that, any other questions? I will stand on my briefs.
Thank you. Ms. Quinn, would you address in particular this res judicata argument that the decision as to whether he had ineffective assistance of counsel was decided in his direct appeal? And the second issue, he talks about the victim having lied. That would have been a credibility issue addressed in his direct appeal. So why doesn't res judicata apply here? He had a chance to raise these issues in his direct appeal. He did raise ineffective of counsel in his direct appeal and he lost.
Well, first of all, may I just simply state that Judge Roberts.
Can you speak up a little louder? I'm going to turn up my volume. It may be my volume, but let me.
May I state, can you hear me, Judge?
Okay, just a minute. Go ahead.
Okay, may I state that?
Yeah, oh yeah, I can hear you now. Thank you. It might have been at the very end.
Roberts orders summarily denying this 60-1507 motion was based solely on timeliness.
Right.
That's the only thing it was raised based on. And may I further comment that one of the things I remember from law school is that you cannot rewrite the question. You have to respond to what's before you. And so from my perspective, the issue relates to being denied because of timeliness.
Okay.
Furthermore, even if you assume there is a valid res judicata issue, it wouldn't relate to every claim that a person can bring on a 60-1507.
But it would relate to every claim they had against the same attorney.
But what about subsequent attorneys?
Well, he didn't make any claims about subsequent attorneys. His only claim was about Lamb.
But again, the res judicata potentially would only relate to Lamb. But Judge, I'm in a position where we're arguing something that Judge Roberts never put into his decision.
Okay.
Now, Judge Roberts had the records and files before him. If he wanted to deny this motion on any reason other than what he did, he had an opportunity to do that. Okay. So that's my position on that.
So your position is, since it wasn't raised below, basically, we can't address it now, although we do have de novo review in this case.
Oh, okay.
We're not bound really by anything Judge Roberts did.
Well, the thing about it is that if you review the entire case, I think what you're saying that you can do whatever you want to, but it puts the defendant in a bad position when we're basing our appeal only on the reason that Judge Roberts put in his decision. Now, and Judge, I also wanted to say this. the Court of Appeals does not accept frivolous direct appeal motions once a case has been closed. We all know the significance of the finality of a judgment. For the Court of Appeals to review this motion to recall the mandate and to accept it in the direct appeal, it knew the significance of this motion. And to the extent that the statute says a 60-1507 should be bought within a year after the appellate court jurisdiction is terminated, this case falls within that. Now, my argument, Judge, is that it's timely because of this corrected mandate. And even though Judge Roberts did not have an opportunity to consider this corrected mandate, if this court should determine the 60-1507 motion was timely based upon the corrected mandate, the whole case would be moot, and we should be able to go back and do this first 60-1507 motion with appellant having counsel who will represent him. And
Ms.
You're
Quinn,
going to need to wrap up here.
okay. Did someone have a question for Ms. Quinn?
no, that's okay.
Okay, but we follow the law. And I think we've shown you at every juncture how things have happened in this case that should shock the conscience of the court.
Okay.
We've also showed you how this corrected mandate was filed after the Court of Appeals determined it was meritorious. And for those reasons, Your Honor, all we're asking is that Quinn has an opportunity to present a viable 60-1507 motion. That's what we're asking.
Okay. Thank you very much, Ms. Quinn. Any other questions from the panel?
No.
Okay. That will conclude this matter then. We take the matter under advisement. We'll issue a written opinion. I greatly appreciate both of your arguments and your briefing. It was excellent, and we will consider all of it and issue an opinion hopefully shortly.
Thank you, Your Honors.
Okay, thank you very much.
Thank you.
Okay.